New immigration rules for green cards regarding the sponsorship of families and marriage to a U.S. citizen or green card holder are undergoing major changes. As the landscape of U.S. immigration evolves, the year 2025 is set to bring significant changes to the marriage-based green card process. With the potential return of Donald Trump to office, stricter immigration policies are expected. These policies could lead to longer wait times, increased financial requirements, and a more detailed vetting process for couples seeking to reunite. If you are interested in this topic, please pay attention and watch the video through to the end to get all the information. Please hit like and subscribe, and don't forget to push the notification bell for upcoming videos. The landscape of U.S. immigration is set to shift again in 2025, with significant updates to the process for obtaining marriage-based green cards, especially as Donald Trump makes a potential return to office. The expectation is that immigration rules will become even stricter, mirroring the policies he implemented during his first term. These updates could bring about longer wait times, stricter financial requirements, and a more rigorous vetting process for couples seeking to reunite through marriage-based immigration. Prior to 2025, marriage-based green card applicants typically faced a processing time of about 10 to 12 months. The Biden administration introduced some flexibility, such as the option for low-risk applicants to skip the in-person interview and more lenient financial requirements for sponsors. However, with a shift in leadership and the likely return of Trump-era policies, changes are expected to significantly impact both the wait times and the documentation needed to qualify. One of the most noticeable changes in the marriage-based green card process in 2025 will be an increase in processing times. U.S.-based applicants can expect a wait of 14 to 16 months, while those applying from abroad may experience delays exceeding 2 years. This marks a significant slowdown from previous years when processing times were more predictable. Stricter financial rules have also been reinstated, including the return of the public charge rule. Under this rule, sponsors must demonstrate a higher income threshold to prove they can financially support their spouse without relying on public assistance. This policy is designed to ensure that the immigrant will not become a financial burden on the U.S. government. Applicants will need to submit more comprehensive financial documentation, which can include proof of income, tax returns, and bank statements. Under the previous administration, some applicants were eligible for interview waivers, especially if they had a low-risk profile. However, with the new policies in place for 2025, in-person interviews will now be mandatory for all applicants. This means that couples will have to prepare for face-to-face meetings with U.S. Citizenship and Immigration Services, USCIS, officers, who will rigorously assess the legitimacy of their marriage. This additional step adds pressure on couples to provide convincing evidence of a bona fide marriage. As part of the heightened scrutiny under the 2025 policies, USCIS is expected to issue more requests for evidence, RFEs. This means applicants will need to provide additional documents to prove their financial stability, relationship history, and other eligibility criteria. If an applicant's submission lacks critical information or clear evidence, the application could be delayed or denied. Applicants may face a higher likelihood of denial if they fail to meet all the eligibility requirements or submit insufficient supporting evidence. This will undoubtedly result in longer separation times for many couples as they wait for their cases to be processed and reviewed. Marriage-based green card applicants fall into several categories, and each faces different challenges under the updated rules. For example, the IR-1 and County Route 1 visas, which are designed for spouses of U.S. citizens, are facing heightened background checks and increased vetting. This should lead to longer processing times and additional requests for evidence. The F2A category, which includes spouses and children of green card holders, is experiencing slowdowns due to rising backlogs. In addition, the stricter financial requirements have made it harder for sponsors to meet eligibility standards, further complicating the process. Despite these new challenges, applicants who are well prepared can still navigate the process successfully. Here's a step-by-step guide to ensure you meet the requirements. Start with Form I-130. The first step is to submit Form I-130, Petition for Alien Relative, to establish the marriage relationship. This step can take approximately 12 months to process. Once USCIS acknowledges a petition, applicants will proceed to the next stage. Next, complete Form I-485 or consular processing. If you are applying for adjustment of status within the U.S., you will need to file Form I-485. Applicants outside the U.S. will need to go through consular processing and submit the necessary documentation to the U.S. Embassy or consulate. Once your petition is processed, you will receive a biometrics appointment. During this appointment, USCIS will take your fingerprints, photograph, and signature for background checks. Given the mandatory in-person interviews for all applicants in 2025, it is essential to prepare thoroughly. Be ready to answer detailed questions about your relationship, daily life together, and plans for the future. Provide clear documentation such as joint financial records, photographs, and affidavits from friends and family attesting to the genuineness of your marriage. One of the most critical areas to focus on is meeting the financial requirements. Sponsors must now provide detailed financial documentation, including tax returns, proof of employment, and income verification to demonstrate they can support their spouse without relying on government assistance. For those married to a U.S. citizen or green card holder, immigration officers now ask questions like, "Who woke up first?" and "What is your favorite side of the bed?" Spouses can no longer expect a smooth path to a green card through marriage. Immigration interviews are getting stricter under the Trump administration, with officers exercising greater discretion and increasing demands for documentary proof. This change stems from tightened policies introduced during the Trump administration to curb suspected marriage fraud, and it appears these policies have carried over. Immigration attorneys report a rise in detailed questioning and document requests, especially during consular interviews for spouses residing outside the U.S. For those applying for adjustment of status within the U.S., interviews by U.S. Citizenship and Immigration Services are also being conducted with greater scrutiny. Officers will be looking deeper, leaning into their discretion more often than they did in the Biden years. They are already spending more time verifying marriages, and there is an increase in requests for evidence. Ashvin Sharma, an immigration attorney, told Lovnikabi that experts say the increase in evidence requests could soon be formalized into policy. According to Sharma, consular officials are paying special attention to how the couple met, their intention to live together, and how they have maintained a relationship. Since the U.S. citizen spouse is not allowed to attend a visa interview in consular cases, the entire burden of proof lies on documents. These documents have to tell the full story: how the relationship began, the genuine intent to live a married life together, how it's been sustained, and why it is bona fide. That means clear evidence of communication, visits, shared plans, and family involvement. Sharma also noted that Snell Butra, managing attorney at MPZ Law Group, advises applicants to prepare with extensive documentation, including money transfer receipts, call logs, photos, joint accounts, and even life insurance policies naming the spouse. Additionally, be prepared to answer questions about your marital relationship, including your spouse's current employment, salary, education, and any prior marriages. For those married to green card holders, the wait is longer and the scrutiny more intense. A typical 3 to 4 year wait can lead to tougher interviews and questions around the genuineness of the marriage during such long separation. The longer the wait, the more documentation you'll need. Pictures, financial records, and continuous communication are crucial to convincingly show that your marriage isn't just alive but thriving despite the distance, said Sharma. He also warned of the power consular officers have, especially in posts like Mumbai, to issue 221(g) refusals or refer petitions for fraud investigation. Under the current administration, we can expect this trend to continue.